delegates. On the taskbar, on the taskbar at the bottom of the screen, you will see the chat and the Q&A icons. Please use the chat for any comments you may have and the Q&A for your questions, which will be addressed in the 20-minute section Q&A session at the end of the webinar. I'd like to encourage you to submit any questions you would like to ask and to kindly indicate which of the panelists you would like to answer your question. At this point, I would like to call on the CESA CEO, Chris Campbell, to share with us his opening remarks regarding the webinar. Chris?
Thank you, Wally. Thank you, Wally, and good morning to, actually, it's just afternoon. So good afternoon, colleagues, speakers, guests. It's indeed, it is an honor and a privilege to be sharing with you some opening remarks on this first in our series of webinars on our practice notes. And my comment is that, you know, over the years, we as an organization and using the learnings from member companies and over time, best practice information had embarked on the journey of documenting a lot of these experiences and best practice recommendations. And we sort of started getting the feeling that many of our members, a lot of them new, some maybe even long existing, have forgotten about this treasure trove of information that we have actually accrued and also invested time in recent exercises to update. And so the purpose of this particular series of webinars is firstly not of necessity to go into the absolute detail of each of the practice notes, because that would take a very, very long time, but indeed for us to create more awareness amongst our members of the existence or maybe a reminder rather of the existence of these, encourage greater use of them, because, you know, it's absolutely unnecessary for anybody to be, especially newer members. You don't need to reinvent the wheel. There are experiences and the like that have been gathered over time. There's information that we've accumulated that are of value to you, where you don't have to, shall we call it, pay school fees or burn your fingers or any one of those expressions as you embark on starting out your business and growing your business. And so that's for our members. For those on our webinar today who may not necessarily be CESA members, you are most welcome, first of all, and I hope and trust that the exposure to the existence of these practice notes and how much more there is to offer to anyone becoming a member of CESA would indeed increase your appetite for becoming a part of the CESA family, such that you have unfettered access to the detail included in all of these practice notes, not to mention many of the other benefits that we do offer to companies who are members of CESA. So without further ado, I want to wish you all well and trust that you will have an enjoyable and informative session. Thank you, Wally.
Thank you, Chris, for those opening remarks. And I especially enjoyed your promotion of CESA membership, which I personally think is very worthwhile. To unpack today's topics, we have three panelists joining us, and they are Clarissa Ritzo, who's the manager of the Professional Risks Business Unit at Aon South Africa Limited. Aon is a long-standing CESA affiliate. Then we move on to the second speaker, who is Francis Gibbons, who is a professional engineer and a member of the CESA Quality, Risk and Sustainability Committee. And then lastly, but not least, Craig Clark, who is a professional engineer, a CESA past president, and a member of the CESA Supply Chain Management Committee. I would like to thank the panelists greatly for joining us today. They will each deliver their presentations before the proceedings end with a question and answer session and some closing remarks. I would like to just remind them that they've been each allocated 20 minutes for their presentations. The first panelist to address us is Clarissa, who will speak on the topic, the state of professional indemnity insurance within the consulting engineering sector. I would like to hand over to Clarissa at this point. Clarissa?
Thank you very much, Wally. It's important to me to speak about the insurance market because there have been drastic changes to the industry and everybody's been affected. The state of the market is pertinent to the consulting engineer and has a direct impact on their risk management and the insurance profile. Like most specialist insurances, professional indemnity is sometimes administrative, time-consuming, and costly. It is very often attended to at the last minute, but I would urge you not to see this as a grudge purchase. It is most certainly one of the most important insurance covers to have. So forgive me for starting with some basics, but I thought it might be appropriate to touch on why you would need professional indemnity in the first place. It never is as easy as it seems, but if you give advice, design, supervise, or write reports, essentially, if you provide or charge a fee for a professional service, you need professional indemnity cover. And you simply need to ask yourself, what could go wrong? The insuring clause on a PI policy is very specific and is negligence-based. Only if an allegation of negligence is made by a third party will the policy be triggered. It relates to the total amount which the insured entity is legally obliged to pay in accordance with the law of any country, but not in respect of any judgment, award, payment, or settlement made within countries operating under the laws of North America. Some insurers also exclude Australia. The limit of indemnity is based on account of any claim, so this amount must be carefully considered before selecting an option. A very nice feature is that the deductible, or what some may refer to as an excess, is only payable when an award for damages is made against the insured. The policy will provide defense, though, in the interim. This policy would provide cover for a third-party claim against a firm in the event that the third party has suffered a financial loss as a result of the professional service you have provided. Unlike a reasonable person test, in a court of law, a court would look to what the reasonable professional would have done in determining liability. You don't need to be guilty of an error, so to say. You just need to be accused of some sort of negligence. The policy, if triggered, would cover damages, legal costs, expert expenses, and VAT. Insurers have indicated that a day in the High Court ranges from 150,000 Rand upwards. There are a host of ways in which a professional can be held liable by virtue of the office that they hold. Professional liability is of utmost importance. This is the duty owed to the community. For example, a bridge collapse or pro bono work, which is incredibly onerous. What is important here is that regardless of whether a fee is being charged, there is still liability. Then in terms of statutory liability, This is when a professional can be held liable in terms of statute, legislation, acts, or a piece of law. Take, for example, the Occupational Health and Safety Act that dictates what is required from a designer. Generally speaking, when the law is silent on who should be held liable, the professional is in fact held liable. Non-compliance with legislation generally attracts fines and penalties, which are not insurable under this policy. Another form of liability is in terms of the law of delict or tort. All 5 elements of delict must be proven. This is discussed because even if there is no agreement in place, there is still liability. Then contractual liability. Our guidance here is that you should never take on more responsibility or liability than you are ordinarily liable for. Don't agree to things that will prejudice the PR policy. There is a danger in signing documents you have not read. This will not be accepted as a defense, and there is no way out of this. You will be held liable. Over the past at least 13 years, insurance has been in what was deemed to be a soft market. The risk was attractive to insurers, and as a result, there were several insurers wanting to accept the risk. This drove down the premiums, and different covers not usually seen on a PR policy were provided for free. But with PR claims being long-tailed, these claims are now coming home to roost, and insurers have advised that the premiums previously charged are no longer sustainable for the risk that they hold. Unless this trend changes, some insurers have commented that in a few years from now, we may struggle to place PR within our existing South African markets. Personally, I don't believe we will find ourselves in that position, but the thought of that alone is concerning. The insurance arena has now officially entered a hard market. This affects factors such as increased prices, stricter underwriting criteria, reduced capacity, increased deductibles, and more selective risks. This means that all clients across all professions are experiencing increases to their premiums, irrespective of whether they have claimed against their policy or not. And even more considerable rate increases have been experienced by professionals with an adverse loss ratio. Higher minimum deductibles have been imposed on certain risks, and capacity within the insurance industry is challenging. In the past, where one insurer was able to provide 100% capacity on a risk valued at, say, 500 million, as part of their own risk management, on any high risk in terms of business activities or limits of indemnity purchased, insurers will now only offer a maximum of 60%. This means a high risk previously insured by one insurer for 100% capacity must now be co-insured with another insurer, which brings a host of complications. For starters, whoever the lead insurer is gets to dictate the policy wording and the pricing, and the supporting insurer has to accept the lead insurer's pricing and policy wording. If you recall me saying previously that in the soft market, covers not usually provided for under a normal PR policy were thrown in for free, this now becomes challenging as one insurer may not agree with what another insurer's policy wording states. While I mentioned the price increase to premiums, the biggest challenge is actually capacity in the market. In addition, COVID-19 exclusion or the infectious diseases exclusion is now applicable on all professional indemnity policies, irrespective of profession. Insurers have provided us with common claims trends for the past 3 years. The majority of claims relate to defective design, which later led to either collapses or other types of problems that required remedial work. There have been inquiries made by our clients relating to cost cutting or discounting of fees when bidding for tenders, asking whether there would be a negative effect on their PR policies. Insurers will respond and assist on a claim, provided that the quality of work is still maintained and that all the relevant specialists are still appointed. Basically, no corners can be cut. Such discounting shouldn't affect insurance if the quality standards are present. Insurers cannot dictate what the client charges in any event. A huge concern, however, for insurers is that member firms are not reporting their incidents or the possible matters timeously. Engineers would attend site meetings, attend to remedial works, and they would still not notify potential circumstances. Only once a claim emanates, then do they deem it necessary to report. This is automatically seen by insurers as a late notification, and insurers have every right to reject such matters. Of all the professions we deal with at Aon, we find engineers in particular do not notify their claims in time. Post the construction boom, claims frequency and severity have increased significantly. The purpose of this slide is to indicate that it is not immediately evident to demonstrate which discipline is responsible for a claim as soon as it is reported to insurers. Professional indemnity claims take approximately 5 to 7 years to finalize. A lot is involved. Assessors are appointed to determine where the liability lies, which is why you can see that based on 78 CESA claims reported or notified in 2019, 73% of these claims are still undetermined. The claims with the largest impact, however, arise out of civil and structural engineering. Due to the increased number of claims, legal defense costs incurred by insurers have increased significantly, especially arbitration costs. Current unresolved large claims under project-specific PR policies, combined with an increase in PR claims across the various professions, together with the CESA portfolio claims, are bound to influence the local markets adversely. Between 2014 and 2020, the CESA portfolio with Aon moved between two insurers, namely SHA, underwritten by Santam, and R2, underwritten by Hollard. Both have their own claims reports. Between 2014 and 2017, SHA reported what we refer to as intimated claims, valued at over 2.7 billion rand. When a notification is made, insurers look at the amount of the potential claim and the limits of indemnity purchased. And this is how they arrive at this very high figure. But it's obviously cause for concern. Remember, due to the complexity of the PR claims, they generally require investigation, which also add to the insurer's costs. Even if a claim is not settled, insurers still spend money on investigating and defending, which involves specialized assessors, attorneys, and other experts as required. Between 2014 and 2020, however, after investigation, a more accurate figure emerges as the investigations progress, and this number reduced down to 142.7 million rand. Of the 142.7 million, 85 million relates to open claims, with 57.1 million being claims that have been finalized. To put things into perspective, claims are currently 142.7 million. However, premium collected between 2014 and 2019 was only just over 118 million. Like any business, loss ratios are very important, and premium needs to exceed claims in order for a book of business to be profitable. Claims aside, premium is generally calculated based on your fees earned from the previous financial year. The rates charged depend on the various disciplines you are involved in, and PR policies are annual policies which do not renew automatically, and they must be reviewed and renewed each year. We encourage policies that are written on an each and every claim basis as opposed to an annual aggregate limit. We're able to provide quotations for single project policies, but these are very expensive and very few insurers provide this cover anymore. As mentioned previously, a nice feature on the Aon CESA engineers policy is that excesses apply to damages only, so you will not be required to pay the excess for legal defense costs. Approximately 90% of our business within professional risks falls within a binder, where we are able to negotiate the terms and conditions with insurers for the clients who fit within the binder mandate. The balance of our business is placed into the open market. We have a binder for each profession, whereby a market exercise is conducted in advance for all binder clients, instead of having to repeat the exercise for every individual client at their renewal. We are able, therefore, to obtain the best possible extensions and the best possible quotes available in the market. Lastly, we have an incredibly comprehensive wording with extensive extensions, carving back restrictions on traditional PI cover. We're always proud to share some facts with you. Professional indemnity is a specialist line of insurance, and insurers trust our capabilities and our expertise. We sit on various industry-specific committees, including CESA, helping us understand your business. One of our key highlights is our legal risk management services offering, which many of you will be familiar with. The requirement for better risk management is essential, now more so than ever before. As mentioned previously, insurers have taken a stance on being more selective when it comes to what risks they accept. Risk management is of paramount importance. We pride ourselves in providing service excellence. We understand and acknowledge the importance of focused risk management. The built environment has its own unique challenges that we are committed to understanding and assisting and advising on where we can. We have a keen focus on education, which is always a highlight for us at Aon. For example, our involvement in the BCE training programs. The practice notes journey provided us with an opportunity to place a magnifying glass on topics such as liability for negligence, the importance of limitation of liability, risk reduction and claims exposure, and liability aspects of the construction regulations topics, which we primarily believe have a direct impact on the consulting engineer today. Your feedback to us is always appreciated. We want to listen, and we want you to know that you are at the heart of everything we do. Thank you very much for listening to me speak about something that I personally am very, very passionate about. Please feel free to contact me directly or to speak to your Aon client manager or our legal risk team about anything we may be able to assist you with. Thanks, Wally. Over to you.
Thank you, Clarissa, for giving us a great overview of the industry and the trends and so forth, and for presenting so ably on a topic that is of great interest to our members. So thank you very much. Next up is Francis Gibbons, our second panelist, who's going to address us on the topic overview of the purpose and history of the practice notes and the revision of the practice notes. So at this point, I'd like to hand over to Francis. Francis, over to you. Thanks.
Thank you, Wally. Good afternoon, all. As Wally mentioned, I'm a member of the CESA Quality Risk and Sustainability Management Committee, and it's a privilege to be a member of this panel today. I'm going to introduce you to the practice notes, or reintroduce you to them if you are aware of them, and show you how they've been updated, and then I'm going to just switch over to the website, the CESA website, and just take you through how to log in and find them. So first a bit of the history of the practice notes. Also including CESA's history. CESA was in fact formed in 1952. It was the originator was the South African Association of Consulting Engineers, and the initial membership was 30 consulting engineers, so 30 individuals, quite a small number, but it's grown from strength to strength, as we all know. In 1962, coming back to what Clarissa's been telling you about, the first PI scheme was started with Glenn Vaal, who then became Glenn Rand, and then were taken over by Aon. And so there's almost a 60-year relationship with Aon over the years. In 1980, the first practice notes were introduced to assist members in managing their business and their projects, and they proved to be extremely popular, and so have been built on over the years. In 2008, then SAACE became CESA, and I think there was a sigh of relief in the industry because there'd often been a mix-up in the acronyms SASE and CESA, which was then avoided. Then in 2014, sorry, I'll jump a slide there. In 2014, the first revision of the practice notes was undertaken, and they were reintroduced. And then now in 2021, well, it actually probably started 18 months ago, Wally Main has organized a complete revamp of the practice notes again, and hence we are presenting them to you. Okay, so there are a total of 78 practice notes, and to make it easier to find them, they've been divided into these 6 categories: clients and appointments, which has subcategories: agreements, fees and disbursements, and liability aspects. Then there are the construction stage services, which have the subcategories claims and insurance and contract administration. So the type of topics that are covered include how to run a tenderer's site inspection, guidelines for preparing a works contract document, all the setting up a site monitoring team. It's a vast font of experience and knowledge that are contained in these particular practice notes, and which are very useful for well, existing and new businesses in the consulting field. The good practice category covers the insurance aspects, the legislative factors affecting a business, practice operation, and risk management. So they deal a lot with the business side of the running a consulting business. It gives guidance on public liability and third-party insurance, how to meet the requirements of the Skills Development Act, all the acts like the BBB, EE Act, and the sorry, I forget the other one, but the various acts that govern the business rather than the consulting profession are covered in here. So there's a lot of useful information there covering daily practice. Okay, then under the legal responsibility and disputes, there's 12 practice notes there with the subcategories dispute resolution and responsibility and liability, so just the 2 categories. And there's practice notes providing guidelines on how to prepare for being an expert witness, the prescription of claims, preservation of project records, and useful stuff like that in it. Then under professional conduct and development, there's the 2 subcategories, integrity management and professional development. And then the last one, the quality risk and quality and risk management, has the 2 categories as well, the quality and risk. And these practice notes give you guidance on reducing risks and exposure to claims, how to calculate the cost of working at risk and determine a fair success fee, and guidance for what to do when faced with a PI claim, which I'm sure Aon will be pleased if you follow. Okay, so getting started, I'm going to take you across to the website now and just show you how to get in there. The first and important thing to note, though, is that users need to log into the CESA website. So we would like to encourage members to give staff access to the website, they can apply for this through Wally Main, and they'll be given a password and a username, and they'll be able to access it, but they can be prevented from accessing the company, the private company confidential information. So they'll just have access to the practice notes. Also, questions and comments can be logged online and will be redirected to the appropriate expert rather. And practice notes will be updated on a continual basis. So, for example, with the new EXA fee guidelines, the practice notes dealing with fees will be updated, and also as comments are received, the practice notes will be updated. So it's preferable not to download all the practice notes and hold them on your servers to make them available to company staff, because they'll eventually be outdated. And so we would prefer that you do give your staff members access rights and let them get them directly. Okay, so that's the end of my formal presentation, and then I'll now go on to the web page itself. So this is the landing page, the home page of the web page. There's a member login, so you'll log in as a member, and then it'll take you to the member menu, which you see now. There's the button Practice Notes at the fourth from the bottom, and this is the Practice Note web page. So there's quite a detailed search functionality built into the web page. If you know the practice note number, you can type that in, or you can type in or select from the 6 categories that I just went through with you, like clients and appointments, and then any of the subcategories that fall under there, and you can then search for that, and it'll show the practice notes in that subcategory. You'll notice here there are some archived practice notes. So in total there are 92 practice notes, but in fact there's only 78 that are current. The archived ones are practice notes that were available in the past, but which for various reasons have not been updated, either because the legislation's changed and or they deal with something that is sort of no longer dealt with in a consulting practice. But often they have been incorporated into other practice notes. So that's the search you can do there. You can also search on keywords. So if you want to search on PI claims, for example, you can hit that, and it'll give you all the practice notes dealing with PI claims, guideline on reduced standing in civil engineering, the potential for PI claims, and appointments to provide expert technical advice. So that's just some of the keywords that I included there. The other thing you can do is have a full list of the practice notes. So if you click on that, then it'll list all 78 of them below, showing what category and which category they're in, and whether they're current or archived. And you can see the archived ones on tick there. You'll also see the practice note number that you can click on, but you can also just click on any one of these. Like if I click on the Occupational Health and Safety Act, this will show the practice note, which you can then download, open in Acrobat. You'll see each practice note starts with the purpose, the keywords, and the disclaimer. What I didn't mention in in my introduction was that initially the practice notes were called advisory notes, but they were changed over to, the name was changed to practice notes because the legal advice from the member firms was that CESA was attracting liability by calling them advisory notes. Yeah, so they were changed to practice notes. So it's a very simple process to get to the practice notes. If I go back to the main screen, the other thing you can do is, sorry, let me just go back, search to the search function. Right, and here is the ask a question button that we would encourage you to use and your staff to use to ask a question, where you put in your name and email address, and you can put a question in on the practice note. But we would also encourage members to give us comments on the practice notes. If you think that there's something that can be added or something that you don't agree with, you can please give us your comments. These are live documents, and so we would like to be updating them and making sure that they are relevant and up to date. What will happen once you submit this is it will go via Wally Main, and he will direct it to either the author of the practice note or a member of one of the panels of the committees that deal with these practice notes. Wally, I think I've covered everything that I wanted to. So back to you. Thank you very much.
You've got it wrong, Francis. I'm thanking you very much for a great presentation, for giving us the history and purpose of the CESA practice notes, and for demonstrating very well how to search for and access the practice notes on the website. And I'm sure the delegates will find this of great use. So thank you very much. Next up is Craig Clark, the third and final panelist, who's going to address us on the topic of the new EXA fee guidelines, differences between the old and new fee guidelines, and the new or revised CESA practice notes. I'd like to hand over to Craig now. Craig, over to you.
Thank you very much, Wally, and hi there to everybody that's attending. I must say that I'm quite impressed. I don't know if anyone else has mentioned it, but I see we've got 114 delegates or participants in this webinar, which is quite impressive. So as Wally said, my purpose of my presentation is to talk to you about the practice notes and specifically the new EXA guideline. Right, so CESA, as part of the development or production of the new series of practice notes, we have produced a practice note number 45, which is a brand new document. And it is what we call an applications guide to help members and clients understand and use the new EXA scope of services, which was published in March this year. And just for the record, in case any of you are not aware of it, the official short title of the document is the EXA Guideline Professional Fees. The full title is, as written there, the Scope of Services and Tariff of Fees. The important thing is that it was published in Government Gazette 44333 of the 26th of March 2021 as Board Notice 22 of 2021. So it is there, it is officially published. You can also find it on the EXA website, but when I last looked, it was quite difficult to find, but it is there. One small anomaly on the guideline is that the front cover says that the commencement date is, and then unfortunately it's blank, it hasn't been filled in, but our CESA's interpretation of that is that the commencement date is the 26th of March, 2021. Okay. Moving on, just a brief background because the EXA guideline has gone through some big changes. From about the year 2000 until 2012, EXA published what we popularly call the old guideline, which was updated every year. And CESA had a lot of input into that document. And then in 2012, EXA published a revised guideline, and the big change in that document was that whereas the old guideline had tables or tariffs of fees for percentage fees, the new guideline, as we called it, no longer had these tables of fees, and it instead had a system whereby you went through a process to calculate a fee. And the whole idea was to make it so that the fee had to be calculated. It couldn't be determined simply by looking it up on a table. This caused a lot of trouble, a lot of confusion in the whole industry. Many client bodies were not happy with the EXA guideline and this method for calculating fees. Consulting engineers found it difficult and clumsy to use, and it really did become a bit of a problem. So after several years, in February last year, February 2020, EXA commenced a process of developing a brand new guideline, which went through a whole process in around about August, September. CESA and the public at large were invited to comment on a draft document, which CESA did. We provided extensive comment. We went through a long process of investigating, and we put a team together to work on it. And we submitted comment to EXA in September. And eventually in March of this year, EXA published their new 2021 EXA guideline. And it was done without further consultation with CESA, which is fine. That is what EXA is there for. And they did incorporate many of CESA's comments, but not all. So that's the background to the new CESA guideline, which was published earlier this year. And we can just look at that in a little bit more detail. Just a few highlights. And I think probably the most important thing about EXA's guideline, and this was the guiding principle from 2012 all the way up until last year, is that the guideline, and they've actually said it again in the new guideline, that the guideline is not prescriptive, but is published as an aid to assist clients and consulting engineers in reaching equitable agreement on fees for services offered. Okay, that is most important. So the fees that are presented in that guideline are not intended to be prescriptive. In other words, we are very conscious of the requirements of the Competitions Commission and the Constitution of South Africa, which calls for competitive pricing for goods and services at all levels. So before going into the document in any detail, and obviously we've got some really tight time constraints today, so I cannot possibly tell you all the changes that have happened. We'd be here for the rest of the day, but there are a few that I'll highlight, and I just start by really encouraging anyone who uses that EXA guideline to go through the document properly, read it carefully, make sure you understand it. There are many, many very small, subtle changes that hardly seem to mean anything And yet, when you look at them in the context of the old guideline and the new guideline, there can be a huge difference. For example, in one particular clause, and I haven't got it in front of me now, but there is a one-word change. There's a sentence that says that the old guideline said the consulting engineer should be remunerated for expenses and costs. And those are expenses and costs like traveling and typing and production of drawings and so on. The new guideline has changed one word, and it says the consulting engineer must be remunerated. Now, obviously that has huge implications, because it means that the default is that you have to be remunerated for expenses and costs. So why do I say this? I'm just trying to highlight the fact that you do need to read the document properly. We can't do that now today. So going through the thing generally, there are a few changes in the section that provides definitions and in the preamble to the document. Suggest you read it. I won't say there's nothing too significant, but just read through it, make sure you understand the changes. Then one of the issues that may cause a problem is that in both the old and the new guideline, there's a very clear explanation that financial administration services by default are part of the service that the consulting engineer provides, okay? And I'm talking like things like providing cost estimates, bills of quantities, and that type of thing, and managing the financial administration of a construction contract. So the new guideline says that as well, but what happened is the old guideline, in the scope of services, the section of the document where the services of a consulting engineer are described for each stage of a project, the old document had these financial administration services indicated in italics to make it easy to identify in the document. The new document does not have that, so there may be some confusion between clients and consulting engineers, and it's just suggested you make sure that between your client and yourself as the consulting engineer, you both understand what is intended. Another important but small change is that in the past, if you had to inspect a particular item of equipment or goods or materials off the site, then you were not paid for doing that, but you could claim, let's say, traveling costs. So if, for example, and it certainly happens with my field of expertise, which is mechanical and electrical, where if we often have to inspect large items of equipment in the manufacturer's factory, which could even be overseas. And in the past, we were paid out the traveling costs for doing that, but we were not paid the time. Now, all off-site inspection and testing of any goods or materials is regarded as an additional service, and the consulting engineer should be paid for that. An item that has disappeared in the latest Gazette or the latest guideline is clarity on what is contractor failure to perform. Now, again, both the old and the new guideline are quite clear that where the consulting engineer is engaged on a project which involves the construction administration and the contractor fails to perform, which results in the consulting engineer having to do additional work. And a simple example of this could be a contractor that doesn't complete the work on time and the project gets extended. The intention of the guideline is that the consulting engineer should be remunerated for the extra time involved. The old guideline provided some explanation and guidelines of what was meant by failure to perform. That has been left out of the new guideline, which is a pity, but it is quite an important item. And then for me, the most important aspect of the new guideline, and it's something that is definitely going to cause problems, is the wording of the clause or clauses which describe construction administration. Now, in the old guidelines, as part of the normal services of the consulting engineer, it was stated that, and sorry, I need to just stop here and just explain something. Construction monitoring is described in the old guideline and the new guideline as having 3 levels of monitoring. Level 1 is where the consulting engineer visits the site occasionally at usually once every 2 weeks at a sort of a frequency that you agree with your client, but typically it's once every 2 weeks. And you might have to do a couple of additional visits at critical times, like when it's getting close to completion or something of that nature. Then you've got level 2, which is what we commonly call part-time construction monitoring, where the consulting engineer provides staff who visit the site regularly, perhaps 3 days a week or perhaps 5 mornings a week, but it's not full-time, but it's a regular part-time visit to site, and it's clearly defined in the professional services agreement, and the consulting engineer gets remunerated for that time on a time basis as an additional service. And then thirdly is what is the third level, level 3, and that is where you have a full-time resident engineer on site to monitor the works. Now, what has happened in the new document is that it does not anywhere state which of those 3 levels is regarded as normal services. It does not even explain that once every 2 weeks is a normal service. It doesn't say that it should be level 1, 2, or 3. So the real issue here is that it's absolutely essential that when you draw up a professional services agreement between a client and a consulting engineer, the level of construction monitoring and what is expected of the consulting engineer in that level of construction monitoring must be described and defined very clearly. I can guarantee this is going to be an issue which is going to cause problems in the future, and it's something that I hope everyone present will just take a note of and make sure that you make very clear what your intention is when you actually do a project. And then the real big change that everyone will recognize instantly is the fact that the process for calculating fees in the guideline from 2012 to 2016 has been completely discarded, and essentially CESA has gone back to a system of tables of fee percentages comprising a primary and a secondary fee based on those are based on the actual cost of the works, the project value on which the fee is calculated, and that is to calculate your percentage fees. In essence, the tables are absolutely simple and clear to apply. Unfortunately, there's, and I've said it here in inverted commas, there's an error in the fee tables in that the primary fee has been incorrectly stated in all the tables. So if you calculate the fee, and I can't go into that now, it'll take too long. But essentially what happens is that when you move from one set or step of the fees to the next, there's a jump in the resultant percentage fee because the primary fee is incorrectly stated. It's not really an issue, but it does mean that instead of the fees increasing fairly smoothly along a curve as the project value goes up, it now changes in steps, in jumps, and sometimes those jumps go downwards instead of upwards. So I can see this causing some unhappiness to both clients and consulting engineers, and perhaps it's something that you should all just be aware of and perhaps adjust the fees accordingly, because going right back to the very first bullet point at the top, the guideline is not prescriptive. It can be adjusted to suit the situation. And I'm sure this is something that EXA will correct when they produce or publish the next guideline, hopefully at the end of this year. And then the other thing is that there are tables of adjustment factors, which is nothing new. That was always done in the very old guidelines prior to 2012. So as a typical example, if the project involves alterations to existing works, there is an adjustment factor which can be 1.25, but the whole concern that we have about them is that there is some lack of clarity about the application of some, not all, but some of the adjustment factors, which were described quite well and explained quite well in the 2016 guideline, and a lot of those explanations have been discarded. So you have to apply and use the adjustment factors with some care. So be aware of that. And then the final small issue in the new guideline is that it provides a lot of guidance on how to calculate hourly rates. And it makes the statement in the guideline that EXA publishes hourly rates from time to time. And as far as we're aware, those hourly rates have not yet been published. So we can't find them on the EXA guideline, on the EXA website. So for that reason, we suggest that you use the previous methods, which are described on the EXA guideline, in order to calculate hourly rates if you need to do so. Otherwise, you can use the method described in the actual EXA guideline. Okay, so those were just some of the highlights of the guideline. And then the next item and the final item that I'm going to talk about is CESA's new practice note number 45. And the whole idea of that practice note is to provide guidance to clients and consulting engineers about the new EXA guideline and its interpretation. We get sorry, my phone is making a noise. We get a lot of queries from clients and consulting engineers on how the guideline should be interpreted. And that was the real spark that got this practice note going, because it is a service that CESA provides to its members and to client bodies to try and assist where there's a lack of clarity on or lack of understanding of the interpretation of the EXA guideline. So what we've done is to almost put all of these things together in one very large practice note. And it is more than a practice note, it is an applications guide, and it'll describe a whole lot of what we've been talking about. And just very briefly, the practice note has a whole lot of different parts. It gives you a bit of the history of procurement of consulting engineering services in South Africa and how fees used to be determined. And then there's a small section which is very dear to my heart, which talks about the importance of a professional relationship in our modern business environment. And as I say, that is very close to my heart, because I believe that it is possible to maintain a proper professional relationship between clients and consulting engineers, which are based on the key word to me is trust, care, and mutual respect. Those are what a professional relationship are all about, and the practice note talks about that. It then provides you with a summary of some of the processes of procuring a consulting engineer or consulting engineering services. CESA has a lot of information on that, of course, which has been available for some years. It tells you where to find that and how to apply it. It gives you a description of the structure of a typical professional services agreement. And the main reason for that is that it's quite amazing how many people think that mere reference to the CESA guideline, the guideline scope of services and tariff of fees, is in fact a professional services agreement, and of course it's not. And so the practice note explains what makes up a professional services agreement, of which the CESA guideline is merely one part. The practice note then provides quite a detailed explanation of all the various services that a consulting engineer provides, both as what is known as normal services and additional services. It provides an explanation of different methods for determining fees for consulting engineering services, which can be on a time basis or a percentage basis, which are the common ways fees are determined in South Africa, or on a lump sum basis, or there are certain other ways of calculating it, consulting engineering fees, and that's all described in the practice note. And then finally, there's quite a detailed analysis of factors in the CESA guideline which can influence the fee calculation. In other words, apart from just simply looking up a table and saying, okay, well, that is the percentage that applies to my project, there are many other factors in the guideline which will affect your calculation, because perhaps they're regarded as additional services, or perhaps they're things where the fee needs to be reduced, and the practice note goes into all of that. And then finally, there's just a very brief comment on what I will call the scourge of fee discounting, which it's not my personal opinion, it's the opinion of, I think, most knowledgeable people in the engineering industry, that the current practice of reckless fee discounting has enormous implications, not only for the consulting engineering industry, but for infrastructure development in South Africa. And it's something that everybody needs to think about. And on that note, I think I've said what I want to say, and I hope you've all enjoyed it, and thank you very much. Wally, it's over to you again.
Sorry. Thank you very much, Craig. I was just writing down some questions. It was really an informative talk and very ably presented. And there's no doubt that you're an expert and knowledgeable person in this field. And thank you for sharing the differences between the two guidelines with us. Thank you very much.
Thank you, Wally.
At this point, I would like to pose the questions submitted by the delegates to the panelists for their responses. But before I do, I would like to inform you that you are welcome to email me any questions you may still have or that were not answered during the webinar. And my address is just wally@cesa.co.za. And I will see that your questions are answered. Okay. So at this point, I'm going to call on the panelists to answer questions. So just to give them warning, I'll just tell them who the question's addressed to and who by, and then say the question. So the first question, which was anonymous, is addressed to Clarissa, and it's, how do you define a late notification? Clarissa?
Hi, Wally. Yeah, so a late notification, the way insurers see it is, so long as, and I'm sorry, I can't put my video on for some reason, but let's just try there. There you go. Late notification, generally speaking, insurers want you to report a claim as soon as practically possible. And what that means is, as soon as you become aware of a situation that could potentially cause a claim in future, that's when it needs to be notified. Generally speaking, you have about 30 days. The challenge is that if it is not reported, if it is not notified to insurers as a notification, you do stand the risk of it not being covered when it does eventually become a notification. What's important here is that your premium is not affected by notification. So you will not automatically have an increase in your premium because insurers look at it and they say, oh, there's 7 notifications on this particular policy. Your premium is not affected. It's only when insurers start spending money on the particular matter where they start looking at costs incurred. So it is encouraged to notify any potential claim. And yes, we can argue about this. We've had several questions about this in the past. Do you want me to then notify each and every single little element? And the simple answer is yes. Notify, notify, notify. And that is really our best advice to our clients. Notify as soon as you possibly can. Sorry, just one more thing on there. There are cases where a policy or where a claim has not been notified, and it's purely an error. You know, it wasn't a deliberate non-disclosure, so to say. In those situations, while insurers do have the right to repudiate that claim, Aon always look to go back to the insurers and to see whether that late notification has prejudiced insurers or not. And generally speaking, if the insurer has not been prejudiced, they will still entertain the claim provided that certain conditions, other conditions have been met. So it isn't a straightforward no, but we don't want to leave that particular area open. Rather just notify. It's the simplest, it's the easiest, and it's certainly the most reliable way to ensure that your claim is paid.
Thank you, Clarissa, for valuable explanation. The next question, I think, is addressed to Chris. It's an anonymous one again. If not a member of CESA, can you have access to the CESA practice notes? Probably at a cost. Chris?
Thanks, Wally. Yeah, no, we don't actually sell them as individual pieces. They actually form a suite. So it would be incorrect and inappropriate for anybody to assume that, well, I'll just buy them as I need them. We would have to charge an enormous amount of money in that case. And it's really not about the money. It's about the benefits of membership, of which the practice notes is only one. So certainly, you know, it's one of the benefits that we do offer. and we invite anybody that's interested or curious. If you're a client body, you are always welcome to contact us for advice. That we do offer for free to client bodies who need some advice on extending bids or interpreting certain aspects of the agreements that they've entered into with consulting engineering companies. And so the short answer is no, actually, and I don't mean it in a rude way. Thank you.
Thank you, Chris. If I can just ask you to stay on the floor. There's another question from Pierre Query Poll. Not sure of the wisdom of giving our staff the company's login details. Since the practice notes are live documents, can they not be made publicly available rather than requiring a login?
I think look, we can debate that. I don't think this is the correct platform for us to debate that. Certainly, I would, Wally, we take that back to the membership committee and the committee responsible for putting this out. And let's look at the best way of, firstly, we want to guard the intellectual property that's so developed. And secondly, you know, it must always serve as a benefit to members. So, yeah, I don't think I can give a definitive answer to the suggestion or the question raised.
Oh,
thank you.
Thank you very much, Chris. You off the floor now. The next question is from Dolph Moore, and it's addressed to Craig. I think this one we might have to take offline. He says he's got two questions. The first one is 4.3 of previous Gazette number 39480, items 5 and 6 are descriptive in the guidelines that must be followed in determining fees. So I'm not sure if he's looking, if that's a comment or a question, Craig. And then let me just tell you the next question from Dolph. The new Gazette is not clear and a lot is left open to interpretation, which may just create confusion. Has this been considered with the new guideline? So Craig, if you can answer those, please.
Thank you, Wally. Thank you for the question. I'm not sure that I understand it exactly, but the old guidelines described a process that you went through in order to arrive at a fee. And that process was subject to many variables which really were difficult to determine. They weren't, what's the right word? They were quite subjective in many ways. And we kept getting reports from clients and consulting engineers that they didn't know how to calculate the fees. The new system, and this is why I don't understand the question, the new system is essentially a lookup table. If for a particular project value and engineering discipline and project type, there is you look up the table and you arrive at a percentage fee. So I'm not sure what Dolph means by open to interpretation.
Craig, sorry, can I suggest we not linger on that? We've got a few more questions and we've only got 10 more minutes. Okay. If Dolph wants to ask further, he can just email me and we'll see that his questions are answered.
That's fine.
If that's all right with you, Craig. Then there's a question here from Asheen Singh. It's for Craig as well. Why has the definition of normal services with respect to site supervision changed? It has been commonly accepted in the market.
Yeah, I think the simple answer to that is that CESA was not part of the process of drawing up the detailed EXA guidelines. So we actually can't answer that. It would have to be the EXA people that authored the document that would explain the reasoning. I'm sure they had good reasons. And in actual fact, I think if one reads the wording very carefully, one can understand the intent. The problem is that it's not clear.
Okay. Thank you very much, Craig. Sorry, the next two are also for you. Some tender documents specify the fee guideline that's to be used for pricing. For example, 2011 or 2016. Sorry, it's from Keith Jagannath. Are consultants obligated to use the current guideline?
Yeah, I'm not sure if one of the other panelists would be better qualified to answer that. I mean, the short answer is that when the new guideline is gazetted, the old guidelines are, what's the right word? They are ungazetted, they're deleted effectively. There's a word for it at the beginning of the document. They
superseded, maybe.
No, they repealed. So the old guidelines no longer exist, excepting they still apply to old projects. So clients who use old documents are wrong. Clients did use the 2011 document because there were so many problems with the documents between 2012 and 2016. So I would strongly advise clients to move to the 2021 guideline. And the old guidelines are repealed. Effectively, they don't exist, but maybe somebody else can comment. Chris, I see you.
Yeah, I think the easiest way, if I can suggest, is as a client or even as a service provider, you state up front what version of the fee guideline you are basing the agreement on. Then at least that's consistent, because it can become a problem if your project commenced, say, in 2016, 2017, and you've got the new guideline, and you know, there's because in 2016, you know, what were the rules of the game that you have both embarked on your contractual relationship, and you can't change that unless there's agreement between the parties. Thanks.
Okay, thank you. I think that question's been thoroughly answered. Thank you very much. Then there's a question from Andre Russ, and I'm not sure, maybe Chris can answer this one. And essentially it says the client asks for a discount, the consulting engineers then comply, and the cheapest service provider is appointed. And this, or it cancels all the guidelines, or it negates them, and it's not to the advantage of anyone. And I think they're asking for a comment. Andre is asking for your comment. So
yeah, look, much as Craig has pointed out earlier, certainly the fees are not, the guidelines are not prescriptive. One would hope to think that they were at least based on what would be a minimum sustainable fee. And that's the Pandora's box, which we've unfortunately, too many people have opened and very difficult to close. Is discounting when actually you might be discounting from what is a minimum sustainable fee for your business, or for the industry, or for the ability to employ young graduates and train them without being able to recover any costs. I don't have the answer for how we're going to close the Pandora's box, but certainly I think more and more education around what goes into this fee makeup, so that we can take out of that the assumption that it's pure profit that gets put into people's pockets. One of the most significant impacts of discounting fees has been the fact that companies' margins are so thin that when a graduate comes out of a university looking for a job and the company is unable to invest from those fees, invest in future engineers, we end up with over 700 unemployed practitioners. So, you know, I think there's fault on the part of the clients and certainly on the part of the industry as well. And together we have to look at how can we fix this so that we do not have these hundreds of young engineering graduates sitting at home regretting actually pursuing engineering as a career. So that is, for me, one of the biggest tragedies. Thanks, Wally.
Thank you, Chris. It's, for your wise words to a very difficult question. Francis, would you like to comment?
Thanks, Wally. I think the problem in our industry is not the discounting. Well, it's not the origin of the problem. The origin of the problem is actually in the way that tenders are awarded with a 80-20 or a 90-10 adjudication rule. And you know, until we move away from that to a quality-based selection or a quality cost-based selection, we are unfortunately going to always be stuck with discounting. So I think that our real efforts, and I'm sure CESA is addressing that, is really trying to get back to a quality cost-based selection process for consulting engineering services. Thanks, Wally.
Yeah. Thank you very much. And I might add that that is the system favored, the quality cost-based selection is a system favored by our mother organization, the FIDIC, the International Federation of Consulting Engineers, and it's practiced internationally. And if we can make quality the key factor in the award of tenders, then we will be doing everyone a good deed. Thank you. The last question is, where can I get a copy of the EXA fee guidelines? It's just basically you go to the EXA website, and on the top somewhere you'll find it, and you just download it there. EXA website is EXA, www.exa.ecsa.co.za.